being sued for his use of Breezy Bowl XX or Breezy Bowl 20. Chris Brown just started the US leg of his Breezy Bowl 20 commemoration tour of his debut anniversary and the celebration of its 20th anniversary. And on the same day that he launched the US leg of the tour in Miami, he was actually sued in federal court in Miami for trademark infringement. Now, Breezy Swimwear is a swimwear apparel brand based in Miami, United States of Miami, USA, and they are alleging that Chris Brown has infringed on their Breezy mark and on their Breezy Bowl mark. And they are actually asking the court to stop Chris Brown from using Breezy and Breezy Bowl in connection with the tour and tour related merchandise and or other activities. So how did it all start? In their complaint, Breezy Swimwear states that it has sold swimwear since 2018, and beginning in 2023, they hosted the Breezy Bowl, which they describe as, and I quote from the complaint, an open call show that welcomes models of every shape, size, age, and experience level, end quote. Breezy Swimwear states that it has sold tens of thousands of swimmer items to customers across Florida, the US, and internationally in over 100 countries. Breezy Swimwear states that it publicly announced its Breezy Bowl fashion show or event on May 5th, 2025 through their at Breezy Bowl Instagram account. So they are stating that they are the quote unquote owners of the at Breezy Bowl Instagram account. Breezy Swimwear also states that they own the breezybowl.com domain, and they claim that they had that since Mr. Chris Brown, and they also named Live Nation, Merch Traffic, and Shopify in the complaint as well. So they're saying that they've used breezybowl.com since before the Chris Brown and those named individuals or companies have used it. They're doing all that and setting up the stage to show the court that they have priority use of the mark. They claim in their complaint that Mr. Brown, Mr. Christopher Maurice Brown, did not announce his U.S. tour or his tour until October 2024. And so they're trying to demonstrate that, hey, we've been using this since before the announcement of that tour in October 2024. We have quote unquote ownership of this domain and this social media account handle. We've been using it since Breezy in connection with swimmer related clothing and Breezy Bowl in connection with fashion shows and quote unquote entertainment related services since 2023. So we have priority of use. We're the senior user of the mark, and so therefore we have rights that Mr. Brown and the other named defendants are infringing on. Okay, why am I talking about swimwear, right? Chris Brown is an entertainer. This is a tour. Why am I talking about swimwear? Well, they state in their complaint, in connection with Breezy Bowl 20, Chris Brown released a Breezy Bowl 20 collection, and that collection included swimwear, including bikinis and one-piece swimwear. And so a basic premise of trademark law is that you cannot have a same or similar brand name for same or similar goods and or services. The goods in question here are swimwear, are one-piece bathing suits and bikinis. So Breezy Swimwear is essentially stating that Mr. Brown was using the term or the brand name Breezy in connection with swimwear and bikinis, one-piece bathing suits and bikinis, directly infringing on their mark in with this in the category of the same or related goods. All right. In the complaint, they provide a screenshot. They demonstrate that in the screenshot that there was a bikini and a one-piece bathing suit that was being sold with the term Breezy and or Breezy Bowl 20 on it. As of August 4th, 2025, when I checked, there was no longer any swimsuit or swimwear related items in the shop. And so that's something that I'll bring up later. There was no longer any swimwear in the shop. However, in the complaint, they provide screenshots of swimwear in the Breezy Bowl 20 collection. They also provide in the complaint a screenshot of a Google search, which shows the first hit for the search, I believe, Breezy or Breezy Bowl to be Mr. Brown's tour, and then the second hit to be for Breezy Swimwear. Breezy Swimwear is also alleging that actual confusion has occurred. And so that is another consideration in trademark law, whether people, whether the perceived public or the intended consumer is actually or may potentially be confused between the two marks. And so Breezy Swimwear is saying, hey, folks actually think Chris Brown may be attending their fashion show in the future, or that the Breezy Swimwear brand, the Breezy Bowl, is being associated with swimwear. So folks think that this swimwear and Breezy Bowl are a thing. And so there's actually actual confusion among consumers. And finally, as concerns the allegations, Breezy Swimwear's complaint also highlights the fact that the Breezy Bowls fashion show that they do was actually held at Live nightclub in 2024, and the official Breezy Bowl 2020 after party for the Miami date for Chris Brown's tour, U.S. tour, was held at Live nightclub on July 30th, 2025. And the complaint also mentions that Live Nation um, has a 10%, I believe, equity stake in equity stake ownership in Live nightclub. So all these things are kind of just trying to use to paint a picture that this mark is infringing on their brand, and there's actual and or maybe a real risk of confusion, if there is an actual confusion in some cases, of consumers mistaking the brands. And so, what is Breezy Swimwear asking? They're asking the court for a few things, but essentially, they're asking the court to prevent Chris Brown and Live Nation, Shopify, which is the platform that is being used to sell the tour related merch and merch traffic. I believe I want to make sure merch traffic, I believe, was involved in the design or the manufacturing of the merchandise to stop. They want them to stop using Breezy Bowl, Team Breezy, or any other mark, word, or phrase confusingly similar to their Breezy mark in connection with swimwear, apparel, fashion show services, or related goods and services. So, in my humble opinion, I think that's kind of a big deal. Chris Brown has not been on a U.S. tour for some time. This is the 20th anniversary celebration of his debut album, which was a highly acclaimed debut album, which could be considered an R&B classic, because if you go listen to the album right now, the hits still hit. Many of the songs that were included on that album have become what may be considered R&B standards for individuals who are like looking to enter an industry, that are in the industry. It just really launched this prolific career, and at that time, the album was extremely popular, and propelled him to stardom. He's a very talented individual. I don't think anyone can dispute that. An excellent singer, an excellent dancer, and just an overall great performer and entertainer. So they're asking Mr. Brown and the other named defendants to stop using Breezy Bowl, or Team Breezy in connection with swimwear, apparel, fashion show services, or related goods and services. And again, as I stated, as concerns the swimwear, as of August 4th, 2025, that was no longer in the Breezy Bowl 2020 collection, 20 Breezy Bowl 20 collection online, unless I didn't search accurately, but I think I did. I went in there, and there's a lot of cool sweatshirt, short sets, and things of that nature, but I did not see any swim related items. I saw some hats and things of that nature, but I didn't see any swimwear there. So they probably took that down just to kind of foreclose that argument. They're also asking um, Chris Brown and the named defendants to stop using Breezy Bowl, or Team Breezy to market, display, or sell merchandise, tickets, promo materials, websites, social media posts, signage, labels, or packaging. So they're basically saying shut down the branding for the whole tour. That first ask was more so, hey, stop using in connection with swimwear. But they're even saying, hey, they're even asserting, don't use Breezy Bowl, or Team Breezy to market merchandise, sell tickets, promote the tour, put posts on social media, create signage, labels, or packaging. I think that's interesting. As I stated in the beginning, Um, they are alleging priority of use and saying that they're the senior holder of the mark Breezy in connection with the goods and services at issue. And I think they're for swimwear. I think an argument can be made. Hey, these folks have been using Breezy in connection with swimwear. It's their brand name. What's interesting, I'm going to jump here a little bit, is that prior to this recent incident, they had registered in mark, but the registered mark is every body is a bikini body. And that was registered in class 25 with the USPTO, the United States Patent and Trademark Office, for swimwear, women's clothing, namely shirts, dresses, skirts, and blouses. They claim March 2nd, 2018 as the date of first use, and so that's the date they first used it. And then April 2nd, 2018, as the date of first use in commerce. Use in commerce essentially means that you're transacting business across state lines, and that's what you need in order to register a mark, a use-based mark at the United States Patent and Trademark Office, and also an intent to use, but you don't have to show that interstate use until later for an intent to use based application. The application for that trademark was filed on September 12th, 2018 for Everybody's Bikini Body with the USPTO, and the registration was issued on or about May 14th, 2019. So again, Breezy Swimwear indicates that it's a woman empowerment brand. That mark falls in line with that. Everybody is a bikini body. I think it's interesting that obviously they understand the importance of trademarks and protecting trademark rights, and they protect that tagline, but they never filed for registration for Breezy in connection with swimwear or Breezy Bowl until the instant case, until the instant litigation. So on July 29th, 2025, Breezy Swimwear Incorporated filed for federal registration of Breezy Bowl with USPTO for jerseys being clothing, which is interesting because Mr. Brown is selling jerseys. Like there's some sets that are like, because the stadium tour, a lot of the dates are taking place at baseball stadiums. I know in my city it's taking place at the baseball stadium where baseball events are held here, and so he has like kind of like baseball jersey type um, tops as well as like with matching shorts and things of that nature. So and obviously it says Breezy and or Breezy Bowl with it. So they're filed for federal registration of Breezy Bowl in connection with jerseys being clothing. So I guess maybe their positions that they were using jerseys in connection with their fashion show. It wasn't really highlighted in the complaint, but that's what they filed for federal registration of that mark in connection with those items. And they also filed for federal registration of the mark Breezy Bowl for swimwear, robes, tops, again in class 25, tops as in clothing. And they claimed a date of first use for those items as July 31st, 2023. Now, Breezy Swimwear filed for federal registration of Breezy Bowl on July 29th, 2025, as well for entertainment services in the nature of organizing social entertainment events, entertainment services in the nature of hosting social entertainment events, entertainment in the nature of fashion shows, event management services being organizing and conducting special events for social entertainment purposes in class 41. And they're claiming the date of first use of January 1st, 2023. So that's an expansive registration that they're asking for as concerns the fashion show. And again, as I highlighted earlier, they're asking essentially for Chris Brown and the named defendants to stop using Breezy Bowl or Team Breezy to market, display or sell merchandise, tickets, promo materials, websites, social media posts, signage, labels, or packaging. That's a lot, in my humble opinion. But they're trying to preclude him from using that mark in connection with this tour, claiming priority use or senior rights in the mark. And so that's what they filed for on July 29, 2025, before they filed the complaint in Florida federal court. They also filed for use of Breezy Swim on July 30th, 2025 for swimwear, beach cover-ups, bikinis, all in class 25, claiming June 30th, 2018 as date of first use. And again, as I said, they already have a registered trademark in the tagline, every body is a bikini body. Now, in addition to asking the court to prevent Chris Brown and the named defendants from using Breezy Bowl or Team Breezy in the ways I described earlier, they're also asking the court to direct the Chris Brown and the named defendants to give them the profits from the sale of goods slash merchandise slash services related to the alleged infringement, and for Chris Brown and the named defendants to destruct or recall all of the alleged infringing goods, advertisements, and related materials in their possession, custody, or control. So, it sounds like they're trying to shut everything down. They're trying to shut everything down. I think this is interesting. One point that I didn't say in the introduction, but I think it's an argument that Mr. Brown can make should this case proceed. It's kind of interesting. Will he continue to use Breezy Bowl? Humbly, I'm gonna be honest, when he announced his tour, I feel like there's so much that he could do with it. I feel like he hasn't really had a tour for his US fans. I know he did that show in South Africa that went viral, which was great for him. And everyone's like, we want to experience that energy in the States. And he has a very loyal, a large following. But I thought humbly they could have came up with a stronger brand name for the mark, just because we've heard the quote unquote bowl. So I didn't think it was super creative. That's my humble perspective. I think it was opportunity for him to do something unique. He is called by many one of the greatest generational male talents since Michael Jackson. Again, this is the 20th anniversary of his album. Despite what, not to get into kind of other things that occurred during his career, but just what that album did for music, for culture, for R&B. I thought personally that the name could have been a little stronger, just because I feel like insert entertainer's name bowl has been done before. However, one thing that Breezy Swimwear states in the complaint that if I was part of Chris Brown's team, I would definitely harp on is Breezy is Chris Brown's nickname. Although Chris Brown, or at least Breezy Swimwear stating Chris Brown, announced his tour on in or around October 2024, he's been going by Breezy, C Breezy, some variation of Breezy for quite some time. His fan base, as we know, kind of in this new era of social media, your fan base is giving kind of a name just to kind of engender that goodwill, that kind of loyalty and support amongst your fan base. They've been known as Team Breezy for quite some time. I would venture to say before 2018. So if Chris Brown is known as Breezy, right, and an important factor to also consider in the world of trademarks and or trademark law is that the more famous your brand, the harder it is for other folks to kind of even dance around your brand name, right? Like McDonald's has engendered such goodwill and have such a strong brand name that it's really hard to even get a close or around that mark, right? Like you're just not going to do it because the brand is so famous and it's essentially ubiquitous. So Mr. Chris Brown is a very popular entertainer in the United States, right? And we're talking about the USPTO, the United States Patent and Trademark Office, who goes by Breezy, who often in songs, right,